Abusuama mo aba embracho na so ha AG Politics Avenue. Podcast of September make we make headlines na embre ye bi exumbo. Na Justice Slim Size ekopie mu or hot issue so. Na okasa efa ye Wontumi ye ni 20-year jail term no check said even though Wontumi eka said ono ena ma kwan ema ye state prosecution witness no kwan se onko sama boy nkubia nkube or ne mom anya mining onko kire se enti nipa no ofiri be bia wotetre kumase tra takwa Christia street to sama boy ho eno konya asase a asase no so galamsey land ho eno wade kwa kudua kan se kube o se okeka Wontumi ni nsem no eboma obi enka nkyerɛw ana wohia panyin ena wobu asɛm ne sɛ ne nsɛm no ensisi so onua ɔkansɛm bebree ɛho ebehia sɛ me no mienu ɛbɔbɔ awura just a Slim Size asoɛyɛ abra wagyemrɛ na ɔprobe into the matter AG Politics Avenue.
He has maintained one thing, that I sent a gentleman there to do reclamation. I did not ask him to do mining. Okay. The gentleman said, you and I knew from the one that I was going to do mining because it was reclamation. Why didn't you give me any money or anything to go and do the reclamation? The guy was going to plant coconut. So the guy drove from wherever he lives, be it Kumasi, he drove past all lands, all possible places of planting or investing into coconut plant, and decided that he will go to Samra Boy, okay, not to plant the coconut, but to reclaim the land first, plant coconut on it, and then how many years time coconut will grow for him to get profit. Even if that is business, does it make any practical sense that if you want to plant coconut, you didn't find any place in the whole of places that coconut will grow, but on a particular Galamsey site? You know, when you put all this together, I don't think you need even an adult to come to this conclusion that the story doesn't add up. But that is beside the point. A judgment has been given. We know as lawyers the way to, if you believe that the judgment is wrong, you appeal or you do use other processes to correct it. That is not to say that they do not have the right to say what they are saying. They have the right to say they don't believe that the judgment was fair. They have the right to say it is political persecution. They have the right to say the accused, the prisoner is now a prisoner of politics or political prisoner. That is within their right. But as to whether it is correct, I think that's what we are discussing. And I hold a view that there's no basis for those conclusions that they are reaching.
And this person in question we are talking about, in regards to the coconut farm story, is the accused person turned prosecution witness?
Yeah, is a prosecution witness.
Okay. Could the state have done this case without those two who now became prosecution witness?
Yeah, we could. Just that it becomes easier to do it when you are having someone who is involved in the matter. Before we even, when the police arrested these guys, they had prepared a docket and they brought everything to us, and we saw merit in the docket before we took the decision to convict them. But you see, there is a policy behind the fight, the NDC's fight against Galamsey. The policy is that yes, those on the ground in the Galamsey are breaching the law, but they couldn't be there and they couldn't successfully do what they are doing without some big, rich, influential, as they call them, kingpins behind it. So you'll be wasting your time clearing the guys who are on the grounds at any particular time, because when you clear them, new ones will come, because it's a very lucrative business for them. So new ones will come. So why won't you go to the source? So that is the policy within the policy, statement that we were making.
So Wontumi was the target? No,
it's not as if he's the target. If you say he's the target, it's as if he was sitting somewhere and nothing was happening and went for him.
Well, but if you're going for it after a kingpin, as you described him, then he will be your target. There's nothing wrong with that.
No, going for a kingpin doesn't mean that the kingpin is the target. And all the opportunities that were open to Jedu to plea bargain were also open to Wontumi. And he took advantage of the plea bargain. So it's not as if we said Wontumi cannot do plea bargain, Jedu come and do plea bargain, let's get Wontumi. No. Plea bargain law is available for everyone. And as you can see, he has chosen where to plea bargain. So he could have chosen this one to plea bargain. And even the one ongoing to plea bargain. So Jedu decided that I'm going to plea bargain, and he got his bargain and his reward or whatever it is. And Okum did the same thing. Wontumi said he was not going to. So it's not as if, it's not a question of target. If he wasn't involved, there's no way anybody would have brought him into this case at all.
Right. Did Chairman Wontumi get a free and fair trial?
I believe strongly that he had a fair trial.
A fair trial.
A very fair trial. In fact, the trial was so fair in his favor that the prosecution, we felt that we were even treated a bit unfairly. And I gave you, I mean, from the beginning, I explained to you why we believe so, yeah.
I want to talk about the Professor Frimpong Boateng report because it was it's a hot topic during the campaign period. In fact, the NDC at the time in opposition had promised that it will take it much more seriously than the government of the day. What have you done with it as the Attorney General's office?
So we have received investigative reports. We have made further directions to the investigators to gather other evidence for us to form an opinion on it. And that's what happens with dockets. The investigators, the police, they bring first report, we look at it, we find gaps, we ask them to fill the gaps and then bring them back until we are certain that we have filled all the gaps. Then we take the step to go and then prosecute.
How soon will people see prosecution?
I cannot tell at this point because I don't know what is happening on the field with the investigators.
I see. But how interested is the AG's office in this report?
If we're not interested,
how would you?
If we're not interested, the government is interested in it, and if we're not, and we have told Ghanaians that we are going to work on it. If we are not interested, I don't think we will make any of such promises or claims to Ghanaians.
Well, those are claims, but action. Do you feel that the action is matching the claim?
I've just told you what has happened. I just told you that there was investigative report, which we have identified gaps and have asked for further evidence. But why shouldn't we be interested in it? And if we are not interested in it, why should we ask them to go and investigate or give us a report in the first place?
Move on to something else.
And let me just say this. And I'll be very happy if you can let the public know this. We are so grateful to our investigators on these cases. The police, the IGP in particular, the director of CID, they have been very, 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 effective, very efficient in supplying us with information to do these prosecutions. Yoko, the same way, and the people who work in this institution, they are Ghanaians like all of us, ordinary, average Ghanaian, but they give so much. And if I tell you what these guys go through to get us to court and to succeed in these prosecutions, you'll be amazed. And then the state attorneys. These are young lawyers who have put in all their best. And you could see this country has a future because I feel excited when I see such young people who are so committed and they give their all. They hardly sleep. They are working around the clock just to get things done. I think that it's a proper platform to say thank you to all of them for all that they have done. Ghanaians are grateful to them for their service.
Very well. Let's talk about oral in general. Right. What has happened? What is the latest on attempts to go after people who have been named in the report?
So there are, as you know, there are a number of cases that we are prosecuting now, and a lot more still undergoing investigations. When it comes to, so we have SkyTrain. Yeah. SkyTrain, we have closed our case. That's prosecution. We closed our case. The defense, the two accused persons are supposed to file their witness statements if they wish to. They were supposed to file it. The deadline was yesterday. As of this morning, they have not filed anything. maybe they will file today, maybe they won't file anything at all, but we are going back to court tomorrow to conduct case management conference. So when they come to court, they will probably show why they've not filed. That is if they are interested in filing, because you're not, as an accused person, you are not bound to file anything. You can just come to the box and sit down for the judge to make a determination. So we don't know what the reason for not filing is. So that's SkyTrain. We have Hanan, which has been quite dramatic over the week. That's last week and this week, because after the first accused person was given a leave to travel, we discovered facts which suggested that he is more of a flight risk at the time of his departure than he was when the judge made a decision to allow him to go. For example, we found out the number of luggages he was carrying with him, everything, the fact that he attempted to also go to the bank and to clean his account.
You're referring to when he was taking the trip to the UK?
Yes, and all that, yeah, and the number of luggages he was carrying out. So we suspected that he constituted more of a flight risk than he was when the judge...
His counsel has said he wasn't trying to empty his bank account. So how did prosecution come to that conclusion?
Naturally, what would you expect the counsel to say? To say that, yes, my client was having to clean his account.
Thank you for sitting down with us. Let's start off with the Chairman Wontumi case. We'll consider it a success for, the state in the judgments that it got in the Summer Boy case. But the reactions have been varied, and particularly from the minority side, they call it a political persecution of the Ashanti Regional Chair. How does that come to you?
That cannot be an accurate description of what happened. I mean, this is a case which has been tried fairly, with a lot of the discretion during the trial exercised in favor of the accused person. So let me give you one example. The accused person filed his witness statement a piece, and when I say a piece, I mean he files. The rule is that you file all your witness statements, you disclose all your witness list, and file all your witness statements. Then we conduct what we call case management conference in respect of all the witness statements before we start calling the witnesses and then speaking. But what the strategy this accused person and his legal team did was to file one witness statement, and then we conduct case management conference on it. We finish cross-examining, then they file the next. That is what they did for all the witnesses that they called. In fact, in respect of one of the witnesses, they filed their witness statement. We did CMC on it. We started cross-examining the witness. Then they filed a supplementary witness statement. In the middle of cross-examination, they filed a new additional witness statement for the same witness. So the trial actually truncated. And the judge, normally a judge should not even accept that kind of, but the judge accepted it and allowed us to have a case management conference for that supplementary witness statement for us to now start our cross-examination again. We all saw the manner in which they even ended the case. A lawyer tried the case, participated in the trial fully. A date has been given for him to file his address. A few days to the deadline for filing the address, they applied to court saying that the lawyer doesn't want to, the client doesn't want the lawyer to represent him again. He did not give any reason why the representation will not continue. He just said that he wants to exercise his right to counsel of his choice. And because of that, we also what happened, the trial, the judgment delayed, and the new lawyer had to be given additional time. Then this additional time expired just at the tail end of the judgment. They filed two processes asking the court to refer some matters to the Supreme Court and to postpone the judgment again. Thankfully, we opposed everything that they filed, and then the judgment was given yesterday. Now the question is, if this is a political persecution, and they believe strong, that means that you believe strongly that you are innocent, right? if you are innocent, the manner in which you even conducted yourself to the latter end is as if you knew that you didn't have a defense. And I don't know if you have had the opportunity to read the judgment, but most of the evidence that we have, the pieces of evidence that we have, which the judge relied on, came from their defense. Defense witnesses, the accused person's own comments, his own witness statement, his own police statement. Those were the materials that formed the basis for the conclusion of the judgment. So it will be shocking. It is shocking to me, but that they would say is political persecution. But I understand what we do. This is politics in a way. I mean, what they are doing is politics, and they issued that statement, or they had a press conference when they had not seen the judgment. So do you expect them, now that they've seen the judgment, they will go back and say what we said was wrong? They would never do that. They would rather double down and say things. But so far, I don't think anyone has pointed to any aspect of the judgment that they believe strongly that is so erroneous.
What we have heard them say around the case itself, and perhaps you throw a bit more light on it when you say that the judgment relied on defense statements and that the accused's own testimonies as well. Could that be the reason they say that from the get-go, the state didn't have a case against Chairman Wontumi?
No. You see, the fact that you relied on defense, lawyers will say the best evidence is evidence which is from your adversary. You know, if you accuse someone of stealing and the person comes to say, indeed, I stole, that is the best form of evidence. So that cannot be the basis for their saying that it's political persecution. It shows that they knew that they have done something, or they did something wrong, or they breached the law. And indeed, look, the law says 2 counts, okay? One is about allowing someone else to mine on a concession without the minister's approval. Mm-hmm. The other one is saying that you conducted some activities in a mining concession without, without also basically authorization, right? The only thing that the defense or the accused person has said in all this is that, first of all, he admitted that he indeed allowed the guy to go onto the concession. Mm. This is someone whom everyone knows is a Galamsey person. If you allow a Galamsey person, okay, to go onto your concession at a time when Galamsey was the major problem in that area, and his witnesses testified to that. His own witnesses, the former Western Regional Minister, admitted that the former Deputy Minister for Lands and Natural Resources, and Honorable Mreku Duka, they all said, look, Galamsey was the most important issue that threatened national security at the time.
But he said at the time he didn't know that was what, they were going to do on the land.
Yes, he said that is.
And we're not going to retry the case.
No.
Just to put it into perspective.
Yeah, he said he has maintained.
We and some of the team calls what channel so. Mammy and I was so jam right. That's an so bad in the room.